Judge May, good morning, have a seat.
Thank you.
And when you're ready, we're ready for your opening remarks.
Thank you. Good morning, I'm David May, and it's my privilege to be here. Thank you, Justice Wiggins. Thank you, members of the commission, for all the time and dedication that I know you've already put into it, and all your work here today and tomorrow. I also want to thank the 29 other applicants that are seeking to be on the Court of Appeals. Our judicial system cannot remain strong unless qualified applicants are willing to come forward and take on the responsibility of judging. I'm very proud to be part of this group of dedicated individuals. Like I said, I'm David May. I currently work as a district court judge. I want to do two things today. I want to tell you just a little bit about myself, and then I want to talk about the key issue, and that is the Court of Appeals and what it needs. I'm 47 years old. I'll be 48 in May. My wife, Paula, and I have been married for 22 years. We're both from Kirksville, Missouri, and that's that's actually the second layer of counties down from Iowa, so we grew up about 40 miles from the Iowa border. And to borrow a line from Justice Mansfield, we are Iowans by choice. We came here for several reasons. I was interested in going to law school. Paula wanted to pursue a career in accounting and finance. We wanted a good place to raise a family, and we wanted to be close to our families of origin. We found all those things and more here in Iowa. We found community. We live in the town of Polk City. It's about 5,000 folks. We have the joy of raising two teenagers, Matt, who's 15, and Gretchen, who's 18. They go to high school up in Alleman. Paul has found a successful career, and I've had the great privilege to work for two successful law firms. And now I have the great honor of serving on the district court. And it has been the opportunity of a lifetime and continues to be for me. I have fantastic colleagues to work with, a never-ending variety of opportunities for learning and service. While my practice in private practice had been primarily on the civil side, I've had the chance to learn about and apply family law and criminal law, post-conviction relief actions I presided over, administrative appeals, and really gain a breadth of experience that has helped me round out my background, so to speak. Now, about the Court of Appeals. I really consider it to be somewhat of an unsung hero of our judicial system. Every year, 1,100, 1,200, 1,300 decisions, thoughtful decisions, timely decisions. They provide a tremendous service to our court system and to the people of Iowa. I believe I can help for 5 reasons I'd like to talk about today. First of all, the Court of Appeals is a place where we need people who want to work hard and put in long hours, and I hope that my record has shown that through school, through private practice, as a district judge, I have had a tradition of working hard, and I intend to bring that tradition to the Court of Appeals if I'm given that opportunity. Second, it's important to remember the specific kind of work that the Court of Appeals does, because not every lawyer and not every district judge really enjoys research and writing, and yet that is the great bulk of the work that the Court of Appeals does. And throughout my legal career, legal research and writing has been one of my favorite professional activities. It continues to be today, and I think that would serve me well in the court. The third point is that I bring a diversity of experience to the court. I've lived in rural areas, I've lived in urban areas, I've worked at a very small law firm, Hawkins & Norris, when I started out, that represented primarily plaintiffs and individuals and very small businesses. I had the opportunity to work at a larger law firm, the Bradshaw Law Firm, that represents a wide variety of clients, including some medium and larger businesses. And throughout that process, I've had the personal opportunity to represent a wide variety of people. I've represented farmers, a pharmacist, a prisoner, numerous other individuals, small businesses, medium businesses, larger businesses, some that were successful, some that weren't. And I think that having represented a wide variety of clients That helps me understand the perspectives of a wide variety of attorneys and a wide variety of litigants, and that helps me to make sure that everybody involved in the system is getting a fair shot, which is really a primary purpose for any judge. The next thing to remember is that while Court of Appeals judges have to work long hours on their own, research and writing and analyzing the record, they're also part of a collaborative process. And that's a little bit different from the job of a district court judge. When you're a district court judge, you can write up a ruling today, and you can hit send, and that resolves the issue. When you're part of the Court of Appeals, you need to be able to work together with a panel. Maybe it's Judge Doyle and Judge Tabor, and the three of us need to come together and come to a resolution. I have considerable experience in working with groups to make important decisions. Both at Hawkins and Norris and at the Bradshaw Law Firm, we would regularly work in teams of lawyers who would bring together our various points of view to come up with the best solution for the client at any given time. Also, another example would be when I was on the Bradshaw management team. This is a 3-person team. We were in charge of managing a law firm that had 80 employees, and we would make decisions on a regular basis that directly impacted the lives of our employees and their families and our clients and the future of our firm. So I'm very comfortable with that kind of collaborative decision making. The last points I want to make about myself and the Court of Appeals are the attitudes that I think that any Court of Appeals judge needs. And there are 2 things to think about. One is independent thinking, and the other one is collegiality. When a new Court of Appeals judge comes in, and let's say it's Judge Doyle and it's Judge Tabor, highly respected judges, that new judge has got to be ready from day one to come in and say, I've looked at this case, here's my point of view, let's see where we agree and where we disagree, and maybe on most of the cases we'll come to a 3-0 decision, but you need to bring that independent point of view. You need to be willing to agree or disagree depending on what your thoughts are, and occasionally that means that you're going to write a concurrence or dissent, and that's perfectly fine. In fact, it's part of the process and how the law develops. The flip side of that is that all judges need to be dedicated to collegiality, and that means providing our support and our comradeship to one another, and ultimately working as a team, because the 3-judge panel may disagree on one case, but we need to work together civilly and with respect for one another, and then we need to work on the next case as a team and continue on that process. So, the long story short is that what I think the Court of Appeals needs are hard workers who love research and writing, who have broad experience, who want to work together in teams, and that's the kind of person I am, and that's why I think I could contribute.
Thank you, Judge May.
Thank you.
Ms. Pearson?
No question.
Ms. Bowden?
Yes, thank you, Judge. You have practiced both at a small firm and a large firm. Can you please tell me what the differences would be as a lawyer in those 2 practices, since you've done both?
I think that in any given setting, the lawyer always has the responsibility to bring what resources they can to a case, and to adequately represent the client no matter what it is. In a small firm, sometimes you have a difference of resources. Sometimes there are more folks available to help out on a case. Sometimes there are less. But in each case, you need to be able to adequately represent the client. And there are some kinds of cases where maybe you'll want to affiliate with somebody else from another firm. When I was at Hawkins and Norris, for example, the firm was representing the state of Iowa against the tobacco companies, and we collaborated with some other firms to make that representation work. No matter who it is, though, no matter whether you're at a small firm or at a big firm, I think that there are very similar problems, and putting the client first, no matter what, is the priority.
Thank you.
Thank you.
Mr. Berger?
No questions?
Mr. Diaz?
Could you retell me the quote from Lex Hawkins about brevity?
Thank you. Lex Hawkins talked to me about writing, and he said, I'm sorry I wrote you such a long letter. I didn't have time to write a short letter. And the moral of the story is that editing matters and brevity matters. And when we're writing, if we can make our writing simple and brief and explain things in a manner that is simple and brief, that's going to help everybody in the system. And that takes work. Just sort of going through and throwing out all your thoughts, that's stage one, but you need to be willing to go through and edit that down and cut the fat, so to speak, and make it as brief and concise as you can.
No questions.
Mr. Bevel?
No questions.
Mr. Sukup?
No questions.
Ms. Sinclair?
No questions.
Ms. Diekma?
Thank you. Judge May, you have had the experience to actually present oral arguments to the Court of Appeals here and the Supreme Court, and now you're a district judge on the bench. Do you think there's different audiences for the different benches, whether it's district court and you're writing an opinion versus you're now applying for a Court of Appeals job? Could you please talk to us a little bit about your thought process in that regard?
Thank you. First of all, my dad always said to me when he was alive, don't write anything down unless you expect somebody to read it. And when you are writing, whether you're at the district court level, the Court of Appeals level, the Supreme Court level, don't expect that it's just going to go in a file and nobody's going to read it. Now, more people will read it if you're on the Court of Appeals. More people will read it if you're on the Supreme Court level, because it'll be out on the internet for the world to read. But you can always expect somebody will be reading it. And what does that mean? That means that while you often need to deal with uncomfortable facts, difficult circumstances for people, you always have to be respectful towards everyone involved. And that's the lawyers, the litigants, their families. When we have a family law case, for example, we're talking about people's children. We're talking about the relationships in their home. And we have to talk about those things frankly, but we have to remember that those children may grow up and read those opinions, especially if they're out on the internet at the Court of Appeals level. So there's always that question of respect that always has to be part of it.
Thank you.
Thank you.
I just want to interrupt for a second. I like Lex Hawkins, and he was a great lawyer, still is, although he's retired now, but it was Mark Twain who said, I don't have time to write a short letter, so I wrote a long one.
Oh, okay, thank you, Justice Wiggins.
Go ahead, Mr. Goodman.
Thank you.
I could see Lex taking credit for it.
I was thinking the same thing. Thank you.
Judge May, we had a chance to talk in my office, and I ask every applicant this question about question 23, which relates to your experience before you got on the bench, number of jury trials and number of appeals. One asks over a 10-year period looking back, and the other asks for a 20-year period looking back. I think your number of appeals were 25. The number of trials you listed were 2, but I think in our discussions, if we looked over your entire career, you had about 16 jury trials. Is that correct?
I have presided over 16 jury trials as a district court judge.
Okay.
And that absorbs about 3 years of that 10-year period that you're looking at. And then I had 2 jury trials as a lawyer during that 7-year period, and I had 1 bench trial. And forgive me, I don't have a hard number for you this morning, but I had additional jury trials from the beginning of my practice, and non-jury trials, and arbitrations before the American Arbitration Association, and contested proceedings before a school board. One of the great benefits of working at Hawkins and Norris was that Glenn Norris wanted to get me in the courtroom as soon as he could. And even before I was a licensed attorney, Judge Mark W. Bennett let me second chair in a federal jury trial with the approval of the other side. So I do have several other experiences as in jury trials and non-jury trials that weren't captured by that 10 years. That's
Okay.
correct.
Thank you. I must have written a 16 down and attributed the number of trials you had tried as a lawyer. the four characteristics that are important to me for this job are intellect, work ethic, decisiveness, and as you mentioned, collegiality. I think collegiality is obviously well demonstrated by your appearance here today and what I know about you on the bench. I'm not gonna ask you about your intellect because your paperwork demonstrates that. Order of the Coif, high honors, and I see you're drinking smart water here today.
I hope it helped.
But I do want to ask you about two things, and you can draw on your experience as a private practitioner as well. Tell me about your work ethic on the bench and in private practice, if there are metrics that will help us understand how you're going to plow through that workload that the Court of Appeals is going to heap on you. And then tell us a little bit about your role as a judicial officer and your ability to be decisive.
I would say this, that throughout private practice and as a judge, I've been a person that works long hours. My hope was to always get right answers in a timely manner, no matter what the challenges were, and to try to not only work long hours on client issues, but also, as my papers, I think, reveal, I've done a lot of public speaking. I like to do some other writing. Long hours have been a tradition for me throughout my process, both as a lawyer and on the bench. I think that if you talk to any of my colleagues at Bradshaw, they would say that I was there late very often, that I was always available to help other people as well. Because it's one thing to work on your own case, but when people come to your office and they need help on something else, you need to be available. And I've always had an open door policy with regard to that, and I think I contribute in that manner. I'm not sure, I might have missed the end of your question. I'm sorry.
Work ethic and then your ability to be decisive.
Yeah.
Examples where you had to make difficult decisions that were informed by the law and driven by the facts.
Right. So, in a case that we had about a year ago, I was asked to decide whether or not a particular candidate could be on a primary ballot. And when you're talking about elections, you're talking about a very short time frame. And this was a situation where I knew that whatever I had to write would be read by a lot of people. And so also I needed to get that done in a very short time frame because they're starting to print ballots so they can send them overseas. And so I found out on a Thursday that we were going to have the hearing on the following Tuesday. I also had a jury trial going that following week. I was in the jury trial all morning. We started the 2-hour oral argument for the election case at, I want to say, 11:30. We gave them 2 hours. I went right back to the jury trial. I then began at 4:30, as soon as I let the jury go, and talked to the lawyers about the issues that were going on in our jury trial. And I went into my room and I started working on this ruling. And this was an issue of first impression in this case. There was no case to look at that would say this is the answer, that's the answer. It was a question of how to interpret Iowa Code Section 4320 that had not been presented before. And I was able to issue that decision in approximately 48 hours. It's not a terribly long decision, but it addressed the facts, it explained my reasoning, and explained the answer, and I believe it was satisfactory to the parties because there was no appeal.
Thank you.
Mr. Bloom?
I have no questions, thank you.
Ms. Conover?
No questions.
Ms. Roberts? Ms. O'Brien? Mr. Horbach?
Thank you, Judge May. Congeniality and judges. So I'm taking a little different view on this. Who is better to judge the mistakes of a judge? Is it Judge May or Attorney May? And the reason why I say that is because I've been to the I've had cases go to the Court of Appeals and to the Supreme Court. And when I won, I never even read the opinion. When I lost, I read every word. There's nothing more vengeful at looking for mistakes than the losing party. So as a district judge, you are rarely the losing party. As an attorney, you may have had that experience. So which attorney may or judge may is best suited to be on the Court of Appeals?
Thank you for that question. It's an important one. First of all, I'd like to say that I have the best of both worlds, because while I've had 3 years of experience as being a district judge, that's still just 3 years ago. And I remember well the experience of representing clients and having those orders come in and go through them and say, oh my goodness, we lost that? How did we lose that? And having to go through that very experience and figuring out what happens next. And I understand well the need from the litigant's point of view to get an answer that's timely and correct and all of those things. But I do believe that being a district court judge offers a real advantage to me. As I tell my son, as I teach him to drive, you know, you've been riding in a car for a long time, but you've never driven it. It's sort of like you've gone to McDonald's a lot of times, but you haven't seen the other side, behind the counter. And when you go behind the counter being a district judge, and you get to see what it's like to actually have to make those credibility determinations in real time, to decide, is the father or is the mother the more capable parent? Or should this person be given an opportunity at probation? Or can they only be supervised in a prison? When you have actually made those determinations firsthand, then I think you're in a much better position from a Court of Appeals position to grade that paper and to say, yeah, I understand why Judge May did this. I understand the kind of context he was in on this situation. With that said, I'll say there are a lot of great appellate judges that were never district court judges. So I think that all of the candidates deserve consideration based on all of their experiences.
Thank you, Judge May. We're sort of out of time, and we wish you the best of luck.
Thank you all.
And I apologize to you, John. We're not getting there.
You have to get a better seat, John.
You'll first next time.
Yeah.